Welcome everyone to lecture number 28.11. Till now we have discussed article 21. Now we are proceeding for the article number 22. So let us go with that. Article 22. What exactly this article tells? See, this article provides that no person who is arrested shall be detained in custody without being informed of the ground of such arrest. Okay, so there are scenarios that we have seen that whenever the person has been arrested, police used to arrest it very secretly. The motive of that executive is that to not inform the court what is the reason behind the arrest of that person, but this is completely illegal. There are scenarios that has been reported now, but what law said, so it provides protection. This article 22, it provides protection against arrest and detention in certain cases. This article is also not absolute. Okay, so there are exceptions for that. What are those things? We'll see. So arrest and detention in certain cases. This article comes into picture after a person is arrested and detained. Before that, this article is of no use. So it come into role after it comes into the picture. It becomes active after a person is arrested and detained. Okay, arrested and detained, like sometimes a house arrest also happen within a particular area, not in the jail and all. The person has been detained, that he is not allowed to move outside and all. Okay, regarding that thing. So this article, whatever we are telling, that here in article 22, this is not available for enemy aliens. Okay, not available for enemy aliens. What does this mean? So let us suppose currently the relationship with the Pakistan is not correct. Okay, relationship with the Pakistan is not correct. Now any person who, let us suppose, is from Pakistan, has been arrested. So now the executive who has arrested is the person who has been arrested is not bounded with the article number 22. Yes, there are a certain international laws that will be applicable, but not this law. As per this law, there is no protection and detention for the person who belongs to the enemy aliens. Okay, understood? That the certain countries through which the relationship of the country is not good, and the person the country executives are free to arrest that person if there is a requirement, if there is an illegal activity or whatever with the cases. That executive is not responsible to answer to the person regarding that arrest and detention. There will be the other laws, but as per this article 22, that person is not protected at all through this article. So this article is applicable to the Indian citizen and not for the enemy aliens. Okay, second thing, no person who is arrested shall be detained in the custody without being informed. No person who is arrested shall be detained in the custody without without being informed. So it is like the person has to know why this person is going to be arrested. Understood? That if a person is going to be detained or is arrested, that person must be aware the reason of being done to that the reason being for that this act is going to happen on that person. The person must know about that. Okay, so that this tell that no person is arrested shall be or no person is arrested or shall be detained in the custody without being informed. Okay, now no person be arrested only the ground of suspicion. No person shall be arrested only on the ground of suspicion, such as, let us suppose you can murder inside your mind again and again, but no punishment can be given that until and unless that act cannot be done. Okay, police cannot arrest you in the case that you are thinking that in your mind you are thinking that you are going to kill that person. No, until and unless the act is not happened, no such action can be taken against you. Okay, so friend, relative or any third person, so that legal defense will be set. So like if any person is being arrested, so the person, friend or relative or any third person must be aware that why this person has been arrested. It should not be that that person has been arrested and nobody is aware about that, where this person has gone. Okay, it should not be the case. The person, if a person is arrested, then the information must be conveyed. Okay, and second, the no person shall be arrested only on the ground of suspicion. So there is special phrase that we can use for this in exam, that you can murder again and again inside your mind. You can murder inside your mind again and again. Okay, so at the time of arrest, police has to note down the date, time and place of birth. So whenever the person is arrested, a record should be maintained. And what this record tells, this record must have a date, when on which date the person has been arrested, time, at what time the person has been arrested, and the place of birth to which this person has been what is the birthplace of this person, and from which place that person has been arrested. All those records should be there. Okay, all those records should be there. So arresting a body, suggestion has made to arrest before. Whenever there is a arrest has been made to a person, so there is always a suggestion to make the arrest before 10 p.m. That is before 10 p.m. If you want to arrest anyone, then arrest that person before 10 p.m. of the day, or after, this is before 10 p.m. It is not like 10 p.m. like before night 10 p.m. the person should be arrested, and after 6 a.m. the person should be arrested. There has been a case in recently, there has been a case where High Court of Assam judge has scolded police regarding that they have arrested one lady at 4 a.m. They police went into their house and arrested the lady at 4 a.m. The point was that the High Court said that what was that much hurry that you went into that home at 3 a.m. and 4 a.m. in the morning? What was so hurry? Why you don't wait to till 6 a.m.? You should wait. And in anger mode, and with the anger, the judge said that whole police station, whoever the officials were present at the police station, whole will be suspended. But this didn't happen. This was not written in the judgment, but in the flow that judge even said that word to uh, while hearing the case. So so there is a suggestion, like whenever there is a requirement of arrest, so this guideline should be followed. It's a mere suggestion. If there is a very better criminal kind of thing is there, then police can arrest the person as per their convenience, even at the right night of the 2 p.m. They can do so. But on the case, it is always suggested that arrest a person before 10 p.m. and after 6 a.m. But if there is a threat of running away like outside the country, you can go ahead, and lady police office must be accompanying at that time. So whenever there is a arrest is going to happen, lady police must be there. Lady police should be there. Lady police should be present. Okay, so if there it is advised that this is because, let us suppose police is going to arrest a person who live in the house, so there will be a ladies or relatives of that person can be in the house. So that's why it is always advised that ladies police officer must be accompanied at the time when the arrest is going to happen. Yeah, so every person who is arrested and detained in the custody shall be produced before the nearest magistrate. Now whenever the person is arrested, he must be produced in front of the nearest magistrate. He should or she should be produced nearest magistrate within 24 hours. Within what hours? Within 24 hours. So this is the window period. Okay, and no such person shall be detained in the custody beyond said period without the authority of the magistrate. So let us suppose if there is a requirement of a person to be arrested more than 24 hours without producing to the magistrate, it is not allowed. You can't keep a person arrested before more than 24 hours without producing that person in front of the magistrate. If you want to do so, take permission from the magistrate, then it can be extended. Okay, so no such person shall be detained in the custody beyond the said period without the authority of the magistrate. Okay, so why this is 24 hours window period is given? Why this is 24 hours? The time to take produce between magistrate and holidays will not be counted. Now here is the game. Every time this need to be refreshed. Okay, let me pause it. Now here is a game which relate to this 24 hours window period. Within this 24 hours, this produce between the within this 24 hours, time travel plus holidays are not counted. These period are excluded. Now what happens whenever there is a political arrest happen? If you see in the news, whenever the political arrest is used to happen, it always happen in most of the cases, in more than 90% of the case. If you see, it always happen during the holiday period, like Raksha Bandhan is going on. Before the Raksha Bandhan, the person has been arrested, or before the Durga Puja leave is going to happen, the person has been arrested. Okay, so to to get a more time to keep the person in the custody, police used to use this kind of tricks. Okay, so sometimes for Sundays court is closed, so they used to arrest that person on Saturday. Let us suppose there is a holiday, there is a holiday on Friday or Saturday, or a holiday on Monday. So and Sunday is already a holiday. Now what police used to do, police generally used to do, they don't arrest that person before the week where Monday is not a holiday, or they don't arrest on Wednesday or Thursday. They, in most of the cases, whenever the political arrest is going to happen, so they arrest on Saturday. They arrest on Saturday, so that they will get 2 days grace period to keep that person within the custody. Okay, so these kind of tricks used to happen. But yes, as per the law, this 24 hours window period is there, and this 24 hours windows is excluded in the time travel and the holidays. Okay, so that's why there is a saying that jail is an exception. Jail is an exception, but bail is a norm. Okay, there are many things that a police has to follow. They can't do in that way arrest and all, but bail the arrested person can take easily. So these protections are not available to, yes, but this thing, whatever I have said, that jail is exception and bail is a norm, this thing is not available to enemy aliens. Let us suppose a war soldier has been arrested of the other country. In that case, these laws will not be applicable to him. Okay, so this is not available to enemy aliens, and person arrested under preventive detention laws, under preventive detention laws. Let us suppose a government has a fear that a person named A can create a chaos, within the society, can create a danga and fasad and kind of things, riots. That person can create riots within the society. So in that case, government has a right to arrest the person under the preventive detention law, and that person even can't apply for a bail. Bail can't be approved for that person in that case. Understood? So this jail is an exception, bail is a norm. That theory is applicable to the normal citizen, to every citizen of the India, but it is not available to the alien enemies. Every citizen of the India, and even for the foreign citizens, but not to the enemy aliens and person arrested under preventive detention laws. Okay, so this preventive detention laws is also called as a house arrest. This is also called as a housed arrest. Okay, so now we'll see how many kinds of detentions are there. Okay, how many kinds of detentions are there? Detentions are of two types. One is called punitive. And another is called preventive. Okay, now what is punitive and what is preventive? We'll see. Under punitive, it is said that after crime, sentenced to 14 years jail. Okay, so this is, let us suppose, like a person has been awarded a punishment by the court, so that can be the detention. So a person has done a crime. Let us suppose he has done a crime. After crime, he was sentenced to 14 years of jail. Okay, now what is preventive? What is preventive? Preventive is a suspicion from a like the person can commit a crime. Okay, to prevent that thing, this preventive detention happen. And yes, on the base of suspension, what is the suspicious activity, I'm missing a word. On a base of no person can arrest on the direction without being informed, no person can, on the suspicion, on the base of suspicion, no person can be arrested. This is a law. Okay, but if there is a instinct that that the government feels that no, that person is really a danger, in that case this preventive detention can happen. And this preventive detention is not like that person will live in a jail with multiple prisoners and all. No, the person will have kind of a house arrest. Within the house, the person will not be allowed to roam around. Yes, person can be provided all the food facilities or all inside their house, but at any case the person will not allowed to leave his house. Okay, so that kind of detention is happened under the preventive. So preventive detention is a preventing a suspicious, preventing a suspicion from committing crime, like by house arrest. The best example that I can give you, that when the article 370A and all was being removed from the Jammu and Kashmir, and when the Jammu and Kashmir became the union territory, in that case various leaders of the Jammu and Kashmir were taken as a house arrest, were put under the house arrest. That was called as the preventive detention. Central government was in fear that as they are removing those laws and Jammu and Kashmir is becoming union territory of the India, so there was a fear that there can be a riots, multiple riots and all that can happen within that Jammu and Kashmir region. So that's why they had a preventive detention for them. House arrest was taken place at that time. Okay, so this preventive detention and punitive and all, this comes under the, it comes under the union list, and that's why union government was free to take the decision when this article 370A and all happened in the Jammu and Kashmir. So it comes under the union list. Within the union list, we have the subjects like defense, foreign affairs, and security of India. Okay, second, it also comes under the concurrent list. Within the concurrent list, a state has also the power to make some changes. So like related to the security of the state, if the state feels that person can be put under the detention, punitive or preventive detention, the state can do so. So security of a state, essential supplies, public order, but nowhere this is under the state subject. It is present under the union list also. Union list can take decision, union list can take a detention decision based on if these subjects are lies under if the person issues is related to these things, a state government can take decision on that. If the person is related to any of these things like security of a state, that essential supplies, public order. Essential supplies means what? We have seen in the year of I guess 2020 there was there were hike in the price of the onions. Onions were selling at 150 and 180 kg per 180 per kg. At that case, if they imported onions from Greece and all, from those reason India imported the onions. So in that case, essential supplies related to that Indian government, central government was liable to take any decision on that. Okay, so yes, if any issues are lying from these decisions, detention can happen with respect to the union list. If anything is happened to related to this order, security of a state, essential supplies, public order and all, yes, union list can take union government can take decision. Even state government can take this decision if it relate to the security of a state, essential supplies and public order. If any person, let us suppose if a person is doing a fear, there is suspicion that a person can affect the essential supplies currently. Like when I am making this video in 2023, currently the tomato price is 200 rupees per kg. Now this will be essential supply for the government, and if state government feel that a person is suspicion, there is a suspicion that person can create a problem, that person can create a chaos, so in delivering the essential supplies, so yes, detention can happen for that person on the basis of on the ground essential supplies. Let us suppose another example, in the COVID scenario when the vaccine was getting delivered, in that case also essential supplies related rules, regulations, detentions, all those aspects, on the basis of that state government can take decision, and as these things are present under the concurrent list, union government can also take decision on these three related subjects. And what are these things, we'll discuss more in detail about the subjects: union list, concurrent list, state list. We are going to discuss later also, and in previous starting also we have discussed those things. I'm just giving you a glimpse of it. Okay, now, so what are the quick points? The preventive detention cannot be exceeded. The first thing, that this preventive detention cannot be exceeded 3 months. Okay, 3 months, unless an advisory board reports sufficient cause for extended detention. Okay, let us suppose then advisory board has been set up and they are telling that no, this person still there is a requirement of the person can put on the preventive detention, that can be extended for 3 plus more months, but ideally the person cannot cannot be put under the preventive detention more than 3 months. If there is a requirement of more than 3 months, then advisory board should be there and they should submit a report that why this person is required of the extension of the detention. On that basis the decision can be taken. Okay, now the ground of detention should be communicated to the detainee. So okay, if the person who is detained is called as a detainee, and the person must be aware that why he or she has been put under the detention. Okay, but if that ground deal with the security, sovereignty of the nation, then also that person cannot be informed. Okay, if the topic for which the person has been put under the detention, it deals with the security, sovereignty of the country, it is very sensitive issue, so that detention may not be informed to that person, as we have seen in the Jammu and Kashmir case. The person was aware that why he was going to be arrested, but the government didn't feel the reason to convey for regarding that detention, the reason for the detention. The detainee should be offered an opportunity to make a representative against the detention order. Yes, the person who is put under the detention, the detainee has the total right to keep a representative and opportunity to make a request, file a case against this detention and all. Okay, so this was all present under the article number 22. Okay, so we'll quickly see, I will quickly read out only what exactly the things are present under it. So article 22 provides that no person who is arrested shall be detained in custody without being informed for the ground of such arrest, and no arrested person can be denied the right to consult and to be defended by a legal practitioner of his or her choice. Okay, I guess I forgot to mention that point, that no arrested person can be denied the right to consult and to be defended by a legal practitioner of his or her choice. Even in a case if the person is unaffordable, person can't afford the fees of the legal practitioner, then government must provide a legal practitioner to that person. Okay, because this is a right of a person, right to consult. The person is getting right to consult from this article 22, that the person has a right to get a consultation. Okay, and every person who is arrested and detained in custody is to be produced before the nearest magistrate within a period of 24 hours, where I have mentioned within the period of the 24 hours, and arrest excluding the time necessary for the journey from the place of arrest to the court of magistrate, and no person shall be detained in the custody beyond that period without the authority of the magistrate. And yes, this period excludes the time of travel plus holidays. Okay, and the above safeguard is not available to an enemy alien and a person arrested or detained under a law providing for the preventive detention. This is not available to a person for the every enemy aliens and the person who is arrested under the preventive detention. Okay, so the constitution authorizes the legislature to make a laws for the preventive detention for the security of the state, the maintenance of public order, or the maintenance of supplies and services essential to the community for reason connection with the defense and foreign affairs. Okay, all those things I have mentioned it here. So constitution is free, the parliament is free to make a law related to the preventive detention, related to the subject if it requires, if it connects with the subject defense, foreign affairs, security of a state, that it directly come under the union list, and even if it relate to the security of a state, essential supplies, public order, even on that case, on that subject also, parliament can make a laws, because this falls under the concurrent list. On the concurrent list, both state and parliament can make laws. On union list, only central government can make a laws. On the state subject, only a state can make a law on that. Okay, I hope you have I hope you have understand this thing. If you have any doubt, please connect with me on social media handle, or you can comment over there. Please subscribe this channel. This is a new channel. I really need your support. Thank you.